There is no end to the list of topics about which separated and divorcing parents can find themselves in dispute. Vaccinations and the decision on whether or not to vaccinate a child against typical and preventable childhood diseases such as measles, mumps, and rubella is one of them. One parent may be pro-vaccine, the other may be firmly in the anti-vaccine camp. The COVID-19 pandemic brings these kids of parental disputes to the forefront. As scientists around the world scramble to come up with a vaccine, a difficult question looms on the horizon for parents who are a child separately when a COVID-19 inevitably becomes available. Which of them gets to decide whether the child should have it? In most situations where one parent has a court-ordered sole custody of the child and the other parent has access rights, the major day-to-day decisions about a child's medical health and well-being are placed in the custodial parent's hands. However, in a recent Ontario case, the court spelled out the decision-making authority between the parents and split it out as well. It gave custody to the mother, but gave the father the express right to make the final decision on whether their 7-year-old child gets vaccinated, including for COVID-19, if and when that vaccine becomes available. The court noted that Canadian and worldwide public policy in favor of vaccinations and a distinct lack of verified scientific evidence to prove that they were harmful. It chronicled the mother's reluctant and often deceitful behavior around getting their children vaccinated in the past. Despite a well-accepted medical advice from preventing common childhood diseases. With the view to the child's best interests, the court accordingly ruled that the father was best placed to make decisions on the child's vaccinations. In light of this, more reasonable views on the topic respecting COVID-19 vaccines, specifically, the court added, since the trial ended, a world health pandemic has been declared relating to COVID-19. It is generally accepted that the pandemic will only end when the population achieves herd immunity, either through wide exposure of the virus in the population or by introduction of an effective vaccine which is accepted by the population. Should a vaccine against COVID-19 become available, these parents will have to decide whether their child should be vaccinated against it. Since children and young people often show little or no reaction to the virus, the decision to vaccinate a child may be informed by public health concern that COVID-19 is a virus that easily spreads and which disproportionately harms older people and people with challenged immune systems. When and if such a vaccine becomes available, both parents should meet with the child's doctor to discuss vaccination for the child against COVID-19. In the event that the mother refuses to attend this meeting with the father and the doctor, or at the meeting refuses to consent to the child being vaccinated, the court granted the father, as an incident of custody and access, the unilateral power to consent to the child being vaccinated against COVID-19. The court said that it has no bias against vaccinations in general and will be able to decide this issue, the father has no bias, and will be able to decide the issue on the advice he receives. The father decides that the child should be vaccinated, and if the child's regular doctor is prepared to administer the vaccination to the child, the father shall arrange for the child's regular doctor to administer the vaccination. This same procedure should be adopted generally as the need for regularly scheduled vaccinations arise during the childhood. So what do you think? Did the court get this one right? Let us know. You can like and share this video. You can subscribe. You can comment at the bottom, and we'll endeavor to answer everybody's questions and comments at the end of each week. Stay safe, and until next time. I'm Russell Alexander.